In the world of law, accuracy is everything. We strive for fairness and truth. One of the biggest threats to justice is hearsay evidence. Imagine a friend telling you about a robbery he saw and you repeating that story in court. That's hearsay, a statement made outside of the courtroom, used to prove the truth of the matter. Hearsay evidence is generally inadmissible in criminal trials. Why? Because it's unreliable. We can't cross-examine the person who actually made the statement. This means we can't test their memory, their perception, or their honesty. It denies the accused a fundamental right, the right to confront their accuser. The dangers of hearsay are obvious. Memories fade, details get distorted, and misunderstandings happen. Allowing this type of evidence could lead to wrongful convictions based on shaky foundations. That's why the law has developed strict rules about when hearsay can and cannot be used. These rules, enshrined in legislation like the Criminal Justice Act 2003, aim to strike a balance. We need to protect the integrity of the trial process. But we also need to recognize that sometimes hearsay evidence can be valuable, even crucial, in getting to the truth. The Criminal Justice Act 2003 is a cornerstone of the English legal system. It governs many aspects of criminal trials, including the use of hearsay evidence. Section 114 is particularly important. It sets out the general rule against hearsay, but also provides a framework for its admission in certain circumstances. Think of Section 114 as a gatekeeper, carefully controlling the flow of potentially unreliable evidence. It recognizes that while hearsay is generally undesirable, there are exceptions to the rule. These exceptions are designed to ensure that justice can be served, even when relying on out-of-court statements. The Act lists several gateways for admitting hearsay evidence. One gateway allows hearsay if the person who made the statement is unavailable as a witness. Another allows it if the statement is so significant to the case that excluding it would be unjust. Each gateway has its own specific conditions. Section 114 also introduces safeguards to ensure fairness. For example, the judge must be convinced that admitting the hearsay evidence wouldn't prejudice the fairness of the trial. This careful balancing act ensures that the pursuit of justice isn't achieved at the expense of a fair trial. It's important to remember that Section 114 doesn't give free rein to hearsay evidence. It simply acknowledges that there are situations where the potential value of such evidence outweighs its inherent risks. The decision to admit hearsay is never taken lightly. Imagine a key witness in a trial passes away before they can give evidence, or perhaps they're too ill to attend court. Should their crucial testimony be lost forever? Section 116 of the Criminal Justice Act 2003 provides a solution in such situations. This section allows